Good morning. Our clients have come to us seeking advice in relation to the setting up of a family law practice. This practice is to be a one-stop shop for clients, with counselling services, psychology, personal development, and an overall holistic approach to the family law setting. In my research on the topic, I have found that the partnership and the company business structures will most suit our client. I have researched the relevant case law and the Partnership Act in relation to advice about partnerships, focusing on the areas I believe are most relevant to the client. This includes the formation of the partnership, the changes that can be made to the standard provisions as stated in the Partnership Act by way of the partnership deed, and the unlimited liability that the partnership brings. I have also investigated the company business model in the significant areas of concern to the client. I've looked at the Corporations Act, paying particular attention to the registration process and the company constitution and the powers and responsibilities of members. The intention of my advice will be to provide relevant information to the client to ensure they make an informed decision. My recommendation will be to pursue a company model, and the reason for this will be evidenced in the following research I have done. The client will ultimately make their own decision, however, and I am confident that with the research presented, they will make a knowledgeable decision. My research has first taken me to the option of a partnership. As it is the first business for the client, their instinct would be perhaps to go for the easier option. And although it is a very good option, my advice would be that this is not the best option for them. There are many pros to the partnership that are relevant for our client. However, the nature of liability will be the determining factor. Under Section 5 of the Partnership Act, a partnership is formed where persons carry on a business together with the intention to make a profit. The client wishes to bring together several people to create a firm and do so under a firm name as stated in Section 4 of the Act. In the case of Ballantyne and Raphael, the court found that the coming together of a syndicate to purchase land was not a partnership, as there was no intention to carry on a business but beyond the singular transaction. In addition to the business being carried on, the court will look at a number of factors where a dispute arises with the formation of a partnership, as stated in Bailey and Consolidated Bank. The court looks to more than just the shared profits in order to establish a partnership. The client has stated that this will not be a one-off venture, and the intention of the formation is that the business will be ongoing and will be considered a partnership according to the Act and under common law. The principal characteristics of the partnership are that the partnership is not a separate legal identity and that legal liabilities of the partnership will fall only to the partners themselves. As stated in Section 12 of the Partnership Act, all partners are equally liable. In Sadler and Whiteman, the court stated that the name of the firm amounts to no more than shorthand expression, and this ideally sums up the extent that the firm will be separate from its partners. This shorthand expression will be used in the event that a partnership is sued, as there are existing special court rules that allow for partners to be sued as the collective. However, per Section 8 of the Partnership Act, liability will still fall to all partners, and all partners are bound by the actions of all or any of the members. Under the standard rules stated in the Partnership Act, Section 27, the rules are to be applied subject to any other agreements made expressly or implied by the partners, and within these rules, under Section 27, a majority vote will be successful in the decision of ordinary matters. The client has advised they wish to impose a structure that ensures that they are not outvoted on any matter. As per Section 22 of the Partnership Act, which states that variations can be made if agreed to by all, and this would be done upon formation, the client could include a clause to make this change. These standard rules under Section 27 under the Act also state that all partners share equally in profits and capital, as well as contributions to the partnership. As with all the standard rules, this too is subject to any other agreement. The client has stated that they may wish to add more structure to the business and variations under Section 22, and it will allow for this. Section 35 of the Act states that a partnership is dissolved when a partner gives notice. Section 36 goes on to state that upon the death of a partner, the partnership is then dissolved. Now, Section 22 allows variations, as previously mentioned, and in larger firms there are often provisions for surviving partners to remain. However, there is no right to succession in a partnership. Our client has stated that they wish for this business to become a family one in the future and wish to pass it on to their children, which is more difficult in this formation. Section 8 of the Partnership Act binds the partners to all decisions made by each of the partners in the course of the business. This is subject to two conditions. Section 8A, where the partner is not authorised to make such a decision on behalf of the firm, and B, the third party entering into the dealing knows that the person is not authorised. Should the person making the dealing not know that the partner is not authorised to make the decision, and the dealing is not different from that of normal business trade, the court may find that the partnership is liable, as stated in Section 13 of the Act. It is these cases of liability that will be most likely to keep our client from proceeding with the formation of a partnership, which is the liability is more limited in a company setting. Moving on to that company option, unlike the partnership, the company is created by registration, as per Section 119 of the Corporations Act. Prior to this, however, several steps must be taken. First, the client must pick the type of company they wish to form. This is listed under Section 1121 of the Corporations Act. The client's responses have indicated that a proprietary company and one that is limited by shares will be most suitable, as they are not wishing to begin a public company, and they have stated that they wish to have the right to limit rights and responsibilities of members based on their investment. Second, under Section 117 of the Act, they must apply to register the company. This is often done by the purchase of a shelf company that has already been registered and is amended according to the client's specifications, which will expedite the process for them should they wish to go down this route. A company can begin with just one member, as stated in Section 114 of the Act. The proprietary company is a separate legal identity and allows limited liability to befall its directors. It creates what is known as the corporate veil. Limited liability provides a safeguard that will entice investment, and shareholders do not need to be concerned about other shareholders' capacity to contribute, as would be the case in a partnership. There are circumstances upon which the corporate veil will be lifted, however, and the directors may be liable. Examples of this would be in cases of illegal acts, cases of trading whilst insolvent or nearly so, or where a director has acted dishonestly. In Guildford Motor Co. and Horn, a former director, who after his tenure was complete, decided to begin his own company and lure business away from Guildford Motor Co., was found to have acted deceptively. The court decided that the creation of the company was a sham, done so simply to protect the former director's dastardly plans. Section 125 of the Corporations Act states that the company constitution may limit obligations and set out objectives of the company. To help ease the strain of such formalities, Section 135 of the Act states that the replaceable rules apply, unless, as the name suggests, they are replaced. These replaceable rules can be found under Section 141 of the Act. This can act as a guide for those setting up a company, particularly those starting a small company, such as our client. These rules set up the roles for directors, office holders, and members, and create a contract between the company and the director, between the members themselves, and between the company and the members. The company constitution defines each role and what it entails, such as different powers and responsibilities, as well as voting structure, percentages needed to make different types of changes, and how contribution shares and profits are managed. This is an integral part of setting up a company, and not all companies are this large. However, so in Chapter 1, Part 5 of the Corporations Act, there is a small business guide. This guide gives a basic and user-friendly overview of the processes, obligations, and issues that can arise in a small company. Both of these business models have their strong point. The flexibility of the partnership with everything from internal change to the selling of assets or the business itself makes it an attractive option and one that would suit a fledgling firm. From the information I've gathered on both of these business plans, however, it will be my recommendation to the client that the company will be a better option. Although many of the continuing obligations will require more effort and are more formal, as they are wishing to continue the business as a family business and our client hopes to have it grow, and as they also have a young family and are concerned about personal assets, this structure is optimal.